5 minutes, give or take. This other thing got put in here while I was gone, and it is difficult. This is file 23232 LT. It's entitled Sturgis Place Apartments versus Todd Werner. Lance Thornton is here and Maria Matson is here. Mr. Werner, we spent a lot of time with him. I got back this morning and found all of this good stuff waiting on my desk, and I haven't even had a chance to look at it. But Meg Bauer is here on behalf of Legal Aid, and they stuck this in the middle of a very busy felony docket morning. Mr. Werner isn't here.
Your Honor, not to interrupt, but this technically wasn't scheduled until 10:30.
Well, in for a penny, in for a pound. Everybody's here.
Okay.
So Mr. Werner isn't here. So, all right. Do you guys want to talk in a breakout?
I would appreciate that. I tried to call Attorney Thornton, Lance, yesterday, but I know he was still out of town. So I would value a chance to speak with him briefly.
All right, let me see if I can set that up. Mr. Werner, can you hear me?
Yes, Your Honor.
All right, if you'd wait just a moment, this is set at a very inconvenient time in the middle of a bunch of criminal cases. The other case we had took 5 minutes. This one is more involved. So we're going to see where we are with our criminal case. So we've got a number of people waiting here in the courtroom and people at the jail. So Mr. Paul Gibson is the duty attorney today. We've done, I don't know, 10 cases. We got about 15 more. Let's see where we are. You can take a short break. You can do that, but I'm going to address this emergency landlord-tenant case. All right, let's address that. We've got about 10 more cases to go, but Paul can use this time to talk to clients. Let's try to see if we can do this quickly as we can. This is entitled Sturgis Place Apartments versus Todd Werner. The file is 23232 LT. We had several long hearings with Mr. Werner and Mr. Thornton, and Sturgis Place Apartments requested a writ of eviction, which I signed on April 19th. Prospectively. We were here on March 17th, March 24th, March 14th. So on March 17th, we determined that there was an arrearage. Defendant was going to get his income tax refund and pay his rent. We continued the non-payment of rent hearing to March 24th. We determined at that time through April, the rent was $1,586.93. We had a previous emergency hearing on April 14th that I crammed in just before I left on vacation that very morning. The apartment complex wanted to continue and ask for the writ of eviction. He was told on March 24th that he owed $1,586.93 in rent and court costs by April 3rd. That included rent through April. So we did the order, and then the defendant wrote me a letter and said, well, wait a minute, here's all the stuff I forgot to tell you in court. So I set an emergency hearing for the 14th, and Mr. Thornton cleared his calendar and was there. again, at an inconvenient time, but we had a further hearing and I found that you were still subject to eviction. You had not paid the entire amount of the rent. And the writ was to issue April 19th. Meg Bauer might have even been sitting in on one of those hearings. She was observing one of those days, but she's filed an appearance on your behalf and asked for a stay for the writ of eviction. So here we are again. My staff set this for this morning. And I found it here this morning. Did you guys accomplish anything in the breakout?
No, Your Honor.
No, Your Honor.
Mr. Thornton, your position is the same. You wish to proceed with the termination of tenancy?
It is, Your Honor.
I would not have set this here, but it's here and I got to deal with it. Ms. Bauer, what's your position?
The defense's position is that the plaintiff came to this court, Fountain Place came to this court asking to be paid. Mr. Werner has presented them with the entire amount of the judgment, the entire amount of rent due through April 30th, and they don't want to accept it. But they came to this court asking to be paid. He's trying to pay. He just wants to pay his rent and move on. He's prepared to be able to pay his rent for May within the standard grace period. But they're not interested in that anymore. They want to make you make a decision to evict Mr. Werner, even though he has made them whole. Attached to the filing that I have is evidence of the entire payment amount that he attempted to make on April 19th, which was the second deadline you set on April 14th. The basic contention, you're a practical judge, and practically speaking, they came here to be paid. He's got all the money. They don't want to take it. If we want to dive into the law, the technical argument is that a judgment, according to Michigan Court Rule 4.201 KA, a judgment must comply with the statute, MCL 600.5741. The statute says that the judgment the court must or shall determine the amount due or in arrears at the time of the trial. I cited one case, it's Stevens v. Moss, that interprets that statute, but where a statute is clear on its face, no judicial interpretation is truly necessary. But in that case law I cited, they say that the quote is, "We believe that the practice heretofore generally followed of including all amounts due up to the date of the judgment is correct and carries out the intent and purpose of the present statute." So at the time the judgment entered, as you just elucidated for the record, on March 24th, by statements from Attorney Thornton and Ms. Matson from Fountain Place, the amount of rent due at the time that judgment entered was $107.33 for the month of March. Mr. Werner paid $220. Actually, I think I misquoted that number. It's $224. 5 days later, so he paid on March 30th. So he paid, that's 6 days. My apologies, Your Honor. But the amount of rent due or in arrears at the time of the judgment was $107. He paid $224. Yes, you made a record that indicated that the judgment included April rent. I think the record on April 14th was pretty clear that Mr. Werner was confused by that, did not understand that a judgment entered in March could include rent that was due in April. Fountain Place Apartments has a pretty standard 5-day grace period for payment of rent, so the redemption window set was shorter than even the standard grace period. But at the end of the day, Mr. Werner has made available to the plaintiff the entire amount of rent due through April 30th. He is prepared to pay his rent for May within the grace period, and yet Fountain Place Apartments still wants to make him homeless and wants to make you make that decision. So his position is that the writ should be quashed. They should accept the rent through April and get this off your docket.
like I said, we've had 3 hearings on this. And after the second hearing, he wrote me a letter and said, well, hey, here's all the stuff I meant to tell you. So we had the emergency hearing on Friday. And we made a determination at that time that he had not paid the rent. I gave him 5, this goes under the category of no good deed goes unpunished. I gave him 5 days to move out rather than have him to start to move right then. And now I find this stay waiting for me when I get back, an additional expense to Sturgis Place Apartments. They disagree with his representation of the facts. The original judgment, trying to find it. They got all these pleadings on top of it now. Said that he had to pay the rent through April with costs of $1,586.93 by April 3rd. He did not make that payment. Now, I didn't check the box that said it will not prevent the writ of eviction, although I think I told him that. And I did tell him through April. So then he tells me all this stuff about a bankruptcy and a bunch of stuff that didn't have anything to do with this. The contention from the plaintiff was, we told him how much he owed by which date, and he didn't pay it. The judge gave him already 1 emergency hearing. I continued this from March 24th to March 14, which is 20 days. And then I gave him 5 more days. And then he says, well, I've paid everything. So, Mr. Thornton, my recollection of our hearing on the 14th was your contention was the defendant had not paid everything. Could you recite those facts again?
Yes, Your Honor. What happened here is during the 10-day period within which Mr. Werner had to pay, he only made a payment of $224.60 towards that judgment of $1,586.93. So nowhere, that didn't even cover the total of the March rent that was owed, the utilities and the court costs. That didn't even cover that, even if you take out the April rent. So that's the amount that was paid, the $224.60. Mr. Warner did not comply with Court Rule 4.201M or N by filing a post-judgment motion within that 10-day period or appealing the judgment within the 10-day period. He also didn't attempt to make any further payments other than that $224.60 within that 10-day period. So yes, my client is asking me where their rights are in this case to have the order of eviction that was entered enforced under the court rules that, you know, he had 10 days to comply. He didn't comply. If we accept rent after that 10-day period, as the court understands, we nullify the order of eviction, which my client did not wish to do and does not wish to do. It wishes to enforce the original order of eviction and 657-44 that says we're entitled to the order of eviction after that 10-day period. So I can address, I just got back from vacation yesterday afternoon also. So I did not have the opportunity to submit anything in writing. But if
her contention is that everything has been paid, and that's not your representation. So
well, it hasn't, Your Honor. My client will admit that after that 10-day period that he had to pay, they have Sturgis Place has a automatic payment system where the tenants can automatically make the payments, which Mr. Warner tried to do. After that 10-day period, my client shut off that access to Mr. Warner because they didn't wish to accept any further payments after that 10-day period. All of his attempts to pay April rent in full was after the 10-day period. My client does not wish to accept those payments and nullify the order of eviction. So they have not received that money. He did make the offer to pay it. They just, pursuant to their rights as the landlord, after that 10-day period, have chosen not to accept it.
Your Honor, may I
Anything further,
briefly?
Ms. Bauer?
Oh, thank you, Your Honor. I just briefly want to address Mr. Thornton's contention about the timeline under the court rules. And Michigan Court Rule 4.201M starts out by saying, except as provided in Michigan Court Rule 2.612. And this motion was brought under Michigan Court Rule 2.612. So the time limit for filing such a motion, specifically seeking relief from judgment, where the judgment has been satisfied or it is no longer equitable that the judgment should have prospective application, does not need to be brought within the 10-day period. So this motion is timely, and the judgment should be satisfied if they weren't playing around, essentially. And regardless, it's no longer equitable for this judgment to have prospective application. They came to this court asking to be paid. They didn't come to this court asking for termination of tenancy. They came to this court asking to be paid. Mr. Warner has presented them with the entire amount of rent due and owing through the end of the month. We're not even at the end of the month yet. So his position is that the writ should be quashed, although he's amenable to an offer or he's amenable to an adjournment or a settlement that allows them immediate possession if he doesn't pay his May rent within the 5th of May. That's the grace period for May, but he's really just looking to pay his rent and move on with this. He doesn't want to be here any more than the rest of us do. He's got to work. He's missed work for these hearings, but he's got to have a place to live if he's going to keep his job.
All right. The motion to stay the writ of eviction is denied. Maybe the equitable thing to do would be to let him pay his rent. But this isn't an equitable hearing. It's a landlord-tenant hearing, and it's statutory. And I'm bound by the rules. And they don't want him as a tenant. He has made such a nuisance of himself that they don't want to accept. They could, but they don't have to, and I can't compel them to. They could certainly say, okay, we'll take your rent, we'll call it good, and we'll start over in May. With this particular tenant, they do not wish to do that. We had 2 extensive hearings, and after the second hearing, you wrote me a letter and said, here's the stuff I forgot to tell you at the hearing. I gave him a 20-day grace period, and then I gave him another 5 days so he could have some time to move. And he hasn't done anything except rely on his equitable remedies, which he doesn't have. So you can execute the writ of eviction today. You can appeal it, certainly, Ms. Bauer, and ask for a stay in the circuit court. But it's not a matter of equity, it's a matter of law. He hasn't complied with the law, and I've explained it to him at least twice.
Your Honor, may I just clarify that our argument does not rely on equity? Our argument relies on the law that says the amount of the judgment shall include the amount of rent due and in arrears at the time the judgment enters, which was March 24th.
All right, well, that's an interesting question, because I very regularly do writs based on including the rent for the next month. So I guess if I'm not able to do that, we better change 22 years worth of policy. It was important for a number of people when they were asking for emergency assistance, we would include the whole month of the next month. So it's like, if I'm not able to do that, those people are screwed. But I explained it to him. I told him to go back and watch it. Anyway, so if that is an issue and I'm not allowed to do that, then I guess the circuit court could tell me that. But we regularly do it for your clients, adding the next month so that emergency funding can be included in there. Motion to stay the writ of eviction is denied. I will do an order, Meg, so you can appeal it if you wish to.
Thank you, Your Honor.
And I'm very busy. I'll have to do it during lunch if I get lunch. But as Mr. Thornton says, where do our rights start? They're paying for his services for 4 hearings. They don't wish to have this defendant as a tenant, and there is in place a writ of eviction. I will do an order.
Mr. Warner, I'm going to speak with my managing attorney, but I will call you after that.
Well, okay.
All right, thank you.
Thank you, Judge. Thank you, Lance.
Thank you.